and administrative law, focusing on corporate, insurance, and mining tax law, as well as marketing and publishing. She has received her law degree from Drake Law School and graduated summa cum laude from Drake University with a BA in Broadcast, News, and International Relations. Please join me in welcoming Deanne. Deanne?
Mahalo, Joan. And
Thank
mahalo to the Hawaii Rebi chapter for inviting NAR Legal Affairs to be with you today. It's virtual. I wish we could be in person, believe me. But virtual is great because we get to talk to people all over the country without leaving our living rooms because we're all still working remotely in Chicago. So we have a few things to get through today. I'm going to share my screen. There we go. Hopefully, Joan, can you give me a thumbs up if you can see my screen? Sounds good. Okay, thank you. So we are going to talk about 3 hot topics today. First, we're going to talk about website accessibility. Then we'll talk about multiple offers, which I have a feeling you might be seeing in your market. And then we'll talk about texting and calling using your cell phone because we have an exciting U.S. Supreme Court case that was just decided a couple of months ago. So before we get started, I want to point out that these 3 topics are just 3 of about 6 or 7 topics that NAR's General Counsel and Chief Member Experience Officer, Katie Johnson, has identified as those hot topics in broker risk reduction. You can download a complete copy at nar.realtor. The URL is there on your screen. I'll also post it in the chat when we get through, or perhaps Crystal, you could post it in the chat for everyone now. I do recommend that you go and download this for yourself, share it with your agents, share it within your offices, share it within your Rebi chapter. And all of the resources that I'll talk about over the next few minutes on these topics are all available through this download as live links. So you can download the PDF or just look at it on the actual web page. Okay, so with that, I'm going to get started. And as Crystal mentioned, please use the Q&A function. She'll be reading those questions to me as we go along. So if you have a question that pops up, just put it in the Q&A and Crystal will read those to me. Okay, let's get started with ADA website accessibility. So what's the issue? Why are we talking about this? Well, the American with Disabilities Act website accessibility claims continue to be filed in large numbers. The numbers have stayed pretty steady from 2019 into 2020, but businesses across industries, including real estate, have seen waves of demand letters alleging that the business's website is inaccessible and a violation of the ADA. Now, real estate brokerages across the country have also recently been receiving kind of a new wave of these letters. NAR has received reports that the letters are being sent on behalf of an entity called Pursuit of Respect, and they allege not only ADA violations, but also Fair Housing Act violations. Now, while the ADA's application to websites remains unsettled, as we'll see in the next few minutes, NAR has done extensive research and found no legal basis for the assertion that the Fair Housing Act imputes any kind of general or specific obligation on real estate professionals to ensure effective communication with individuals with disabilities. In other words, the ADA piece of this is unsettled, but the research that we've done is that any violation or any alleged violation of the Fair Housing Act really has no basis when it comes to website accessibility. So with that, let's just do a quick refresher on the ADA. Those of you who may have been in the business when the American with Disabilities Act was first passed, there was a lot of training about what does this mean for our physical spaces and places of accommodation. So Title III of the ADA prohibits places of public accommodation from discriminating against individuals with disabilities and obligates businesses to ensure effective communication with individuals with disabilities by providing them with auxiliary aids and services at no additional cost. So the ADA's requirement to make physical spaces accessible is clear and undisputed. But over time, the issue of whether the ADA applies to our electronic spaces, our websites, and mobile applications has become a more pressing issue as more and more businesses begin conducting business on the internet, either exclusively or in large part. Certainly the pandemic had a lot of people shopping online with the curbside to go, right? Including home buyers and home sellers who are finding their agents, finding homes online. The ADA's application to the internet has become a major issue in today's world and in the real estate industry. So what does the Department of Justice say? Remember, the Department of Justice, or DOJ, is the federal agency that's responsible for enforcing the American with Disabilities Act. And they've long taken the position that the ADA requires websites to be accessible. But despite that, the DOJ has not promulgated any concrete rules or regulations as to what that actually means. And there's no indication that they're going to provide any additional guidance in the future. So what are consumers and businesses to do? Well, consumers have taken the issue to court a lot. So that's where we get the bulk of our guidance for ADA website accessibility is from case law. So this first case, Robles versus Domino's Pizza, is a Ninth Circuit case. And I believe Hawaii is in the Ninth Circuit, I think. I was counsel in Nevada for a very long time, and I actually argued at the Ninth Circuit Court of Appeals on a bail bonds case. I know, random, but I believe Hawaii is in the Ninth Circuit, so this would actually apply to you in your state. And what the court said in the Domino's Pizza case is that if there's a nexus, which only requires a plaintiff to show that an inaccessible website has a nexus to a physical place, that establishes liability under the ADA. And that means that the website and the mobile app have to provide full and equal access to individuals with disabilities. So in this case, Domino's not only had the app and the website, they had a physical location, a bricks and mortar office, storefront, if you will. And that meant that the ADA applied to their website and it had to be compliant. Now, the court didn't actually say what that meant. However, the court relied on the fact that the Department of Justice and federal agencies use what we call WCAG standards, which I'll talk about in just a moment, and that the Domino's website had to comply with those standards. It rejected the argument that Domino's said, look, the DOJ hasn't told us what we need to do, and said, look to the WCAG standards. So that's the holding in Domino's. But just about 6 weeks ago or so, we got really good news from the 11th Circuit Court of Appeals in the Gill versus Winn-Dixie case that said websites are not places of public accommodation, and that the Winn-Dixie website is not a barrier to a disabled consumer's ability to full and equal access to enjoy the goods and services of the store. So in this case, although there obviously is a store where a person goes to purchase groceries and there was a website, the court said, that nexus that the Ninth Circuit used did not apply. And the district court in Gill had held that the website was inaccessible and a violation due to the incompatibility of the website with screen readers that individuals with visual impairments use. But the 11th Circuit said, no, they clearly reversed it, relying on the clear and unambiguous text of the ADA, the actual American with Disabilities Act law, noting that the list of public places in the law does not include intangible spaces. It only included tangible physical spaces that need to be compliant and accommodate individuals with disabilities. So that's really good news for businesses in the 11th Circuit. But what that does for the nation as a whole, for the industry as a whole, is it sets up what we call a split of authority. So now we've got the Ninth Circuit saying one thing, the 11th Circuit saying another. This sets up the possibility that the US Supreme Court will actually weigh in on this issue and provide us with some concrete guidance. Until then, what we know is the DOJ's position is that websites need to be accessible. And so the safe bet is to make your website accessible to prevent any intangible barriers to full and equal access to goods and services. As I mentioned before, many courts are looking to the Web Content Accessibility Guidelines, that's WCAG, as the standard of accessibility. Now, this most recent iteration, the 2.1 AA standard, was adopted in June of 2018 and adds several criteria to covered businesses to address accessibility of mobile applications. So not just your website, but if you've got a mobile app, that also needs to be compliant. So many people consider these WCAG standards. And as I mentioned before, federal agencies' websites comply with the WCAG standards. So in the tips at the end of this section, we'll talk about, well, what does this mean for me and my business? But now that you know that your website should be accessible, to minimize your liability under the Americans with Disabilities Act, what does that mean? Essentially, an accessible website is one that can be used by people with different disabilities, and it still provides them with the same the same information that someone with no disabilities would be able to retrieve and access from the website. So for example, a blind person would use a compatible screen reader. So the website needs to be compatible with screen reader software. There have to be audio descriptions for videos, properly labeled images and alternative text for images. Someone with epilepsy can't have flashing content. So, a constantly, sparking GIF or something on your homepage that, is constantly flashing would not be good for someone with epilepsy. So websites need different types of accommodations and different types of elements, and to be compatible with different types of devices and software that make websites accessible for many people with different disabilities. So what are you supposed to do as a broker? So you may have a website. The first thing to do is to assess your website and create a plan. There are a couple of cases where the courts have said, look, this business is doing the best it can. It has a very comprehensive plan. It's making changes to its website. As things come up, they're addressing those. And so courts have found that businesses weren't liable if they have a plan in place and they're actually working the plan. So you may need to consult an accessibility expert to create a plan and really look at all the different aspects of your website, from images to buttons to screen reader compatibility, and see what changes need to be made to bring your website up to WCAG standards, and then create a plan to do that. And then, of course, execute on the plan. Talk to your website provider. See what elements are already available from your website provider for your website. And when you enter into vendor contracts, include accessibility and indemnification language so that you're covered and that you're making that a part of your standard web agreements. And the easiest thing to do, and this is something that your website provider or your web person can do right away, is include an accessibility statement on your website. You can go ahead and go to nar.realtor/accessibility and pretty much copy and paste NAR's accessibility statement to your website. And what that does is it alerts someone with a disability that there are alternative methods and alternative means of accessing the information, including calling and speaking with a person at the business to help the person navigate the website. So those are some tips for you to take into consideration in making your websites accessible. We're going to stop here for a brief sip of water and also ask Crystal if there are any questions on this topic in the Q&A yet.
do have one attendee who has a hand raised.
Okay.
Jennifer, do you have a question? I'm going to allow you to speak. Go ahead. You need to unmute.
Hi, can you hear me?
Yes,
Yes.
go
Hi,
ahead,
Jennifer.
Jennifer.
Just wanted to let you know I accidentally hit that button.
Okay. Okay, other than that, then we do not have any questions, Deanne.
Great.
So
And that does happen, Jennifer. Most definitely. All right, so let's move on. Oh, wait, sorry. This is apparently an extra slide. So there are some resources. If you downloaded the PDF that I talked about at the beginning, all of these resources are on there. Crystal, I'm also happy to make this presentation into a PDF. If the attendees would like that, you can send that out to the folks that attended today, and that will have all the links in there so people don't have to take screenshots or try and scribble down long URLs.
that would be wonderful. Deanne, I do have a couple of questions if you want to go back and
Sure.
Chris Prendergast asks, how broad is the concept of disability?
Oh, that's a great question. So disability is, defined in the ADA, and the slide, let me see if I can go back to that slide. So these are the types of disabilities that the WCAG covers. In terms of, so it's not so much the disability, it's what do the standards say, and making your website compliant with those standards, which in and of itself will address the different disabilities. So visual impairment, audio, persons who are deaf, mobility issues, people who can't use a mouse, for example, and even epilepsy is one of the covered disabilities.
Okay. And I do have another question.
Sure.
From Gina Chun. She says, what about sites like Zillow and other sites that take our information and repost our information? Are we liable?
Oh, that is another great question, Gina. So I would look at the terms of use for Zillow and any of the other platforms that you syndicate your listings to. Typically, those are written so that the platform is not responsible for third-party content. However, I don't know the specifics of the Zillow agreement, but Zillow is such a large institution and player that it would surprise me if their website was not, or they weren't taking steps to make their website ADA accessible. And that is a fantastic question that I'm going to forward on as well to our ADA website accessibility in-house person who addresses those issues, and see what she can find out about that. So stay tuned. I will do further investigation.
Okay, I do have one hand that's raised, and I would prefer if everybody typed their questions into the Q&A. However, I'm going to go ahead and allow Stephanie Nojima to go ahead and talk. So Stephanie, do you have a question? You can go ahead and unmute yourself.
Sorry that I made a mistake as well.
Okay, no problem. Thank you. All right, Deanne, I think we're ready to proceed.
Great. Thanks, Crystal. Okay, so multiple offers. My goodness, this has been front and center, like headline news in our industry for months and months. And I worked with the Risk Management Issues Committee at NAR, and they did breakout groups, work groups on several topics, including multiple offers. And it seems like things, there were multiple offers in the fall, several offers on a property, but it seemed like the springtime things ramped up and accelerated like crazy. And, dozens of offers, hundreds of thousands of dollars over list price is what, some of the anecdotes that we were hearing. So, some of the issues that we see with multiple offers, of course, lots of opportunities for misunderstanding. But when you adhere to a few key principles, and sometimes we just need to go back to the basics and remember what's an offer, what's accepted, like literally contracts 101. And that can help cut through some of the noise and some of the confusion around multiple offers. But I wanted to point out, I have 4, I'm calling them bumps. So 4 particular things to look out for, because there are some pockets of liability in some of the things we're seeing with multiple offers. The first bump I want to talk about are love letters. So a love letter is, it could be a letter, a photo, a video, any communication that accompanies an offer from a potential buyer in an effort to appeal to the seller. They are appealing to the seller's emotions because, you know, all of these decisions, a lot of times they are emotional decisions in addition to financial decisions, as you well know, being out there in the trenches. And love letters, the problem with them is that sometimes they can innocently include information that actually, you know, invites or is a slippery slope to fair housing violations, because it's revealing a prohibited basis for discrimination. So something like, we can see our family celebrating Christmas around the fireplace, or those wide hallways will accommodate my wheelchair, and I've been looking for a house like this for a long time. And when we, again, take a step back and remember that fair housing is all about eliminating discrimination and ensuring that anyone who's qualified can purchase real estate, we can see how these love letters might trigger implicit bias and have sellers making decisions not based on the facts of the offer, you know, purchase price, closing date, contingencies, things of that nature, but they have kids, I have kids, you know, they're Jewish, I'm Jewish, whatever the case may be. Now the seller may be making decisions that could actually lead to a discriminatory impact. So that's the problem that we're seeing with love letters. And remember that accepting an offer based on anything other than the price, terms, and merits of the offer might potentially violate fair housing laws. Now, to be fair, our director of fair housing has not actually seen any federal cases on this particular issue that have been filed, but it is a concern, and it is, the potential is there for fair housing violations. So it's important that you as practitioners always explain the pitfalls of love letters to your clients, both sellers and buyers, and stress the importance of sticking to objective criteria in order to adhere to fair housing laws. Now, the safest, most conservative course is that real estate professionals should discourage the use and consideration of buyer love letters. On the seller side, it could be putting in remarks, love letters will not be considered. On the buyer side, it could be simply, discouraging and refusing to help your buyer draft a love letter, or, not including it with the offer. However, that's maybe a little bit Pollyanna because buyers, they hear about it. Their cousin did a love letter. They read about it in newspapers because now it's being covered by the media. And they think, I want to do that too. It helped this person get their house. I want to do it too. So we understand that ultimately buyers are facing probably the most competitive market that any of us have ever seen and maybe ever will see. And they want to do whatever's possible to find the home of their dreams. So if your buyer absolutely insists on drafting a love letter, remind them to keep it to objective statements like, that kitchen is huge, I cannot wait to cook in it. Or the lanai and the view is absolutely incredible. It is perfect for us to relax at the end of an evening. And just make sure that the letter does not include any references to the buyer's race, color, religion, national origin, sex or sexual orientation, familial status, or disability. And those, of course, are the 7 protected bases in the Fair Housing Act. Also check with your state or local association. They may have specific guidance relative to your state laws. And really, do your best with love letters, but really understand what the potential is and where those pitfalls are. Sometimes with risk management, that's really what we're looking for. We're looking for where those pitfalls, how can I address them? All right, next thing, escalation clauses. So we are seeing these popping up across the country. An escalation clause is one that states if a competing bona fide offer is made on the property, the buyer's offer will automatically increase by a certain dollar amount over the competing offer up to a maximum limit. So again, what are some of the issues? What are some of the pitfalls here? I was actually speaking with a broker just the other day who has basically outlawed escalation clauses in his brokerage because they can get really messy really quickly. So a couple of things to consider, on the buyer side, you've already tipped your hand to what your top dollar is by saying, that's your cap on your escalation clause. And so we've heard that sellers are actually countering at that top dollar price. Some brokers, as I mentioned, don't even allow them because they can trigger additional liabilities, such as documenting proof of a bona fide offer. That may be illegal in some states, or the buyers, the bona fide buyer's offer may have a confidentiality provision in it, so the seller wouldn't be able to provide it. And to be effective, sometimes these escalation clauses may require the buyer to waive any kind of appraisal contingency. I don't know how appraisals are going in your market, but we're seeing these issues of appraisal gaps and sellers wanting proof that the buyer actually has funds to cover a gap if the appraisal doesn't come in. And then the last pitfall to watch with these escalation clauses is to don't write them yourself, because they can be very tricky in how they are applied. And it's always best to make have legal counsel review it, or better yet, use a form that has been vetted by your state association or your legal counsel. So that's escalation clauses. Again, they're very tricky. And actually some sellers agents are saying, we won't accept those either, because they do just get so tricky and so messy. And yeah, gosh, it's rough out there. I feel for you. I really do. The next sort of bump in multiple offers that we're seeing, as buyers are being ever more creative to try and get their offer accepted, we're seeing no contingency offers, meaning they're waiving inspections. They're waiving, they're saying they'll cover the appraisal. They're waiving the contingency of selling their current residence. They're doing anything they can to make their offer the most attractive. But here are some things, here's the pitfalls, things to be aware of. Be aware of what's not waivable. So for example, in a home that was built before 1978, the lead-based paint disclosures are not waivable. The disclosures aren't waivable. There may be state-specific mandates. If there's an HOA, a homeowners association on the property, those documents may not be waivable, or there may be other aspects pertinent to your state law that just aren't waivable as a matter of law. So those things cannot be waived no matter what in an offer. Be aware that sellers may ask for proof of funds to cover that appraisal gap. We are starting to see appraisal addendums being drafted by brokerages and realtor associations to help, again, navigate through this sort of uncharted area of real estate offers and acceptance. And then also keep in mind that your duties under state disclosure law and the Realtor Code of Ethics, your duties are also not waivable. So you still have to disclose any known material fact to the buyer under your applicable state law and the Code of Ethics. And then finally, and here's maybe the biggest one for broker liability, is what happens when the buyer moves in and there's a severe storm and the roof starts leaking, and they call you 6 months after closing and say, hey, this roof is crap. Like, why didn't you tell me to get this inspected? And they put it back on you. They waived their inspections. They waived the roof inspection. They waived everything, but they're still coming back to you as the professional saying, you shouldn't have let me done that, right? So here's something you can do. Work with your legal counsel to create an addendum that acknowledges that the buyer alone, not the brokers, not the agents or the seller, the buyer alone is responsible for personal verification, walkthrough, and inspections to confirm that the property is satisfactory. Put it in writing that they understand inspections are a valuable resource and tool in the home buying process, and they, are, knowingly waiving their inspections of this property, and waiving any claim against you based on such a waiver. So those are some of the issues with no contingencies. Now, here's a new one that I just added this morning, and that is rent backs. I love creative real estate agents and creative buyers. So here's a new twist. Buyers are now putting in their offers that the seller can stay in the property. It could be just a few days. There always seems to be those instances where the seller needs just a couple of days after closing. I remember back in the maybe mid 2000s, there were some issues where, buyers weren't closing on time. Lots of changes in appraisals and loan laws at the time. And so closings were being, sort of delayed, and the sellers were like, well, we're not packing up all of our stuff if we don't know when we're moving. So these, I think, kind of came into vogue then, where, that you might give the seller a couple of days after closing to move out. Now what we're seeing, longer periods of time, stay in a couple of weeks, stay in a couple of months. So these rent back provisions, again, bring their own pitfalls and can be a potential bump in the road for you. So here are some things to consider. Remember that the risk of loss, in other words, who's responsible if a tree limb falls on the roof while the seller is still occupying the property after closing, that risk of loss, generally speaking, transfers to the new buyer at the time of closing. So insurance becomes very important. Make sure that the buyer has homeowner's insurance at the moment of closing. The seller should also continue to maintain insurance. They need to talk to their insurance agent and see if they can convert their homeowner policy to essentially a renter policy to cover their possessions. Make sure that it's clear in writing, who's responsible for damage to the property. If a cabinet door is pulled off or a mirror is broken, who's going to be responsible for that? Again, get it in writing. How many days can the seller be there? What is the seller's move out date? Is an addendum to the purchase agreement enough, or do you need a separate lease agreement? If you're talking 30 days or more, you might need a separate lease agreement. And then that brings up issues. Can you see where this is going? That could bring up issues with the lender. It could bring up issues with the home warranty in terms of timing. So make sure that the buyer's also speaking with the lender, disclosing that they're going to be leasing the property back for a couple of weeks. How much rent will the seller pay? Do you want a security deposit? Will the seller, who's now the tenant, allow the buyer's contractors to come into the home? Are there any state or local landlord tenant issues that might apply? So what I'm saying is, this sounds really good. Yeah, we'll let the seller stay in a few more days, but again, take that step back, go back to the basics, and think through, like, what does this actually mean? What are the things we need to be thinking about and thinking through and putting in writing for this situation? So that's why I added rent backs to today's discussion. It's a new thing. So here are some risk reduction tips. Discuss the potential for multiple offers at your listing interview and get the seller's direction up front for handling multiple offers. Do they want to see love letters, for example? Will they give you permission to disclose the existence of other offers as the Code of Ethics requires? Know your state laws with regard to any duties owed and timeframes for presenting offers and what may be disclosed to the other party in a multiple offer situation. Next, remember Article 1 to treat all parties honestly. While the duty to your client is primary, you must treat all parties honestly. I think if we all remembered that, there would be a lot less confusion over multiple offers. Keep in mind that a poorly drafted love letter can trigger fair housing violations. and discuss the pros and cons of escalation clauses and addendums with your buyers. And then if you're on the seller side, this isn't on the screen, but I'm throwing it in there because it's something that we're, again, hearing more and more of. You know, if you get 20 offers on a property and the seller selects one, let the other 19 know. So it actually impacts their relationship with their buyers. And, you know, you will be the hero, you will be the professional one if you just reach out and let everyone know what the status of their offer is, and if they were unsuccessful with the offer. So just another little risk reduction tip, more of a professionalism tip. NAR has several resources available to you at nar.realtor, including, I did a window to the law video last year on this. There's actually an entire section of the professional standards manual on this that talks about the ethics of multiple offers. It's really good. Take a moment to read it. And then we also have a buyer and seller's guide to multiple offer negotiations. It's a simple Word document. You're free to put it on your letterhead, share it with your buyers and your sellers, use it as a discussion and an education tool for your clients to work through the multiple offer process. So Crystal, I'm going to take another sip of water and see if we have any questions about multiple offers, love letters, anything of that nature.
We do. We have multiple questions. So I'm just going to jump into it.
Okay.
First question is, can you say where they work or go to school?
I would say yes. I would caution the name of the school if it's a religiously affiliated school. Not that all the students who attend a religiously affiliated school are that religion, but that could be seen as, again, it's the potential for discrimination there.
Okay. I have another question from Chris Prendergast. It says, is military affiliation acceptable?
I would defer to your state law. So some states do make military or veteran status a protected class. I apologize. I did not look up Hawaii's for housing law before today's session. And I probably should have. I apologize, Chris. But if it is a state protected class, then yes, military affiliation could be seen as, the potential for discrimination could be there.
Okay. Another question says, broker cover letters are more common than buyer love letters. Anything wrong with disclosing buyer occupations?
Again, I don't think there's anything wrong with disclosing buyer occupations. Just keep in mind those 7 protected classes and any additional state protected classes. And, don't reveal any particular characteristics of the buyer in that nature. But I think occupation, again, as long as it's not disclosing one of the protected classes, I think you would be fine disclosing occupation. But where possible, stick to objective things.
Okay. Chuck Garrett just put a little link into the chat, which states that military is not a protected class in Hawaii.
Okay, great. Thank you for checking on that for us.
Burton Hamamoto says, on love letters, it's not illegal to submit a love letter, and it's not illegal for a seller to read a love letter. It is illegal to make a decision based on a protected class. Therefore, do you think it would be prudent for our state association to produce a disclosure standard form informing the seller of the law and that it is illegal to base their decisions based on a protected class, then sign off on that they are aware and will not base their decision accordingly? Will that at least help get the realtor off the hook for liability?
Really anything that you can show that you advised your client of the law and the client signs off on it, I think is always helpful. As an attorney, I always have to say, you can do everything, get everything in writing. Your client can still file a lawsuit. It takes a couple $100 and a lawyer to file a lawsuit, but having that in writing will immensely help your defense. So I do recommend anytime you can put that in writing and get the client to sign off is a good thing. And I will say the California Association in last October, they actually did create like a discrimination advisory I'm not sure if the clients have to sign it, but it does actually mention love letters in that advisory. So some state associations have taken that step. So I think that would be something to definitely bring to the attention of your association if you'd like.
Wonderful. Peggy Yuan asks, what tips or recommendations can you advise for seller agents to advise their sellers that receive these love letters that do reference things that are TMI?
Well, I think it comes back to having that discussion with the seller ahead of time at the listing appointment. I'm sure you're already talking about the market and say, one of the things we're seeing are multiple offers and the immense creativity of buyers. And, have a frank discussion with them about what some of the pitfalls are, just like we talked about, in the last few minutes, and get the sellers, take the seller's temperature. What are they thinking about that? Now, I have heard that some sellers will read the love letter after they've made a decision. So the love letter doesn't even come into the decision. So they accept the love letters, but don't actually read them. They make their decision based on the objective criteria. And then, read the letter. And if they do want to read the letter, again, as we talked about, you can add that to your listing agreement. Say, you do or do not wish to receive love letters. And if they do, then they understand that, there is potential for discrimination if they make a decision based on one of the protected classes.
Okay, I have one more question and then we
Sure.
can move on. If it's a free two-week rent back, is a post-occupancy form sufficient?
So it sounds like your association has such a form, which is good. In terms of the timing, I would actually defer to your association counsel who or your forms committee who helped draft that form. As long as you're getting it in writing and everything is clear as to the respective rights and rights and responsibilities of the parties, I think a form is appropriate. Again, I'm not sure what form you're talking about or if there are specific time limits on that. But good job getting it in writing.
Okay, that's it. We can move on. Wonderful.
Okay.
Thank you, Deanne.
Thank you. All right. I know we just have a few minutes left. We've taken, but I hope we're getting good information and I love answering questions. So texting and calling. So the issue is, we're going to go through this really fast. The Telephone Consumer Protection Act prohibits anyone from calling or texting a cell phone or a landline using an automated telephone dialing system or ATDS. So that's the issue that's facing real estate professionals. If you're using your cell phone for marketing purposes, TCPA litigation is incredibly expensive, literally thousands of complaints filed every year. Settlement costs are through the roof. So this is a very expensive way to market because of the potential violations of the TCPA. So the TCPA says that using a cell phone or text, you may not initiate any call using an ATDS, that automated system, or pre-recorded voice unless you have prior express written consent. In other words, an opt-in form, something that says, yes, I agree to accept marketing texts and phone calls. And of course, keep those consent forms for your records. But one thing that has helped immensely is the Facebook decision that was decided April 1st of this year. It was not an April Fool's joke. That said, that only devices that have the capacity to store or dial actually using a random or sequential number generator are covered by the TCPA. In other words, cell phones are not covered by the TCPA because your average cell phone, smartphone, does not have a built-in automated telephone dialing system. It doesn't have the capacity to randomly or sequentially generate phone numbers. So the effect of this case is that it overturned a Ninth Circuit decision that interpreted that an ADTS is any device able to store or dial list of numbers. So in other words, if you had a group setting on your phone, whether or not the device used a random or sequential number generator. So this was a great decision for real estate professionals using their phones for marketing purposes. And I love this quote from Justice Sotomayor, that expanding the definition of an auto dialer to encompass any equipment that stores or dials phone numbers would take a chainsaw to these nuanced problems when Congress meant to use a scalpel. So that is really it's a very creative and kind of forceful quote for a justice to have with regard to the other decisions on this that held otherwise, and really expanded an ADTS to include a cell phone. So the result of this, what you need to know is that direct and targeted calls that do not make use of a random or sequential number generator do not require consent. So using your cell phone to make a marketing call does not require consent. Now, the do not call list still applies. This does not affect at all the do not call registry. So make sure that you're still complying with all of your do not call policies. Now, there are a couple of open questions in terms of capacity or use. So there may be a continued litigation, for blast texts and things of that nature. And legislatures may now start creating laws in reaction to the Facebook decision. Now, all of that said, maintaining or obtaining prior consent is still going to be the gold standard in TCPA liability. NAR has this very handy quick reference guide that you can download. The link will be in the materials for when you need prior consent when you're contacting a customer on their cell phone. Again, prior written consent is always going to be the best standard whenever you're sending marketing texts or marketing phone calls to clients or the public. Again, the do not call rules still apply. A couple of risk reduction tips. Consent should be clearly stated, well documented and preserved. In other words, keep the records. Consent forms should state that a wireless number, that it is a wireless number and they agree to receive calls and texts. And of course, you probably receive marketing texts from people that you no longer want to hear from. And you can easily opt out by using the word stop, just texting back the word stop. Make sure that if your marketing system that you're using through your cell phone or targeting people's cell phones has the ability for the end user to easily cancel or opt out of the marketing texts. A few more tips: promptly remove anyone who opts out and keep records of those opt-outs, and talk to your vendors if you're using a third-party marketing system or a third-party vendor to help with your telephone marketing and your cell phone and text marketing. Talk to your vendors about how they intend to comply with the TCPA, if they're changing anything in regards to their business because of the Facebook decision. And of course, do not call compliance is still absolutely required. And make sure that those third-party vendor agreements have an indemnification provision in case their business activities do violate the TCPA. At least you can be protected. NAR has a wide range of resources for you on this, including topic pages, articles, several window to the law videos. All of the links for this will be in that download, as well as in the materials that you will receive after today's presentation. And that is what I have for you. Do we have any more questions? And I think I ended on time.
Yes, thank you so much, Deanne. Wow, you were just ripping right through all that. I do have a few more questions.
Yes.
Brian McCourt says, can the seller's agent withhold a love letter and not give it to the seller?
Can the seller's agent withhold a love letter and not give it to the seller? Again, I think you should have that. You'll know what to do because you're going to talk to your seller at the beginning of your relationship with the seller when you sign that listing agreement. And if you didn't speak with the seller about that when you got a listing agreement, I would speak with the seller when you receive the love letter, and again, explain those pitfalls and ask the seller what their preference is. You know, if the seller is fully informed of the potential for fair housing violations and the potential for discrimination, because you don't know what the love letter says yet, then, you know, take the seller's lead on that. Again, and, you know, put it in writing that you've advised them and this is their decision, and then provide them. Again, the seller may choose to look at it after they make a decision.
Okay, let's see. We have seen that many sellers have a preference for local or Hawaii resident buyers over mainland buyers. What are your thoughts on that?
That, I think, is a very unique question and unique situation. And that is a really good question. So again, we're going to come back to, you know, what are the protected classes? You could say the same about, you know, actual buyers versus investor buyers, that there's a preference for actual buyers over an investor. So again, if my kind of concern, it might be, no, I mean, if it's residence, I mean, residence isn't one of the protected classes, again, unless it's part of state law. But what I would like to do, because that is such a unique question, let me talk to our fair housing director and see what she thinks about that particular question. I don't think it would be a violation in practice, again, because it's not one of those 7 protected classes.
Okay, wonderful. Ruddy Lee says that is photographic ads sent to a phone number allowed? I've received some like that, and I'm just curious.
A photographic ad. So in other words, it's a text ad.
Yes.
So well, first of all, if before April 1st, when we had the Facebook decision, which kind of opened things up, you know, consent is always still required. You can absolutely, you know, reply stop if you no longer wish to receive those marketing messages. But if it was not, it's hard to say if it's illegal or not, because I don't know how it was sent. If it was sent using, you know, a random or sequential number generator, then that would still violate the TCPA. If it was just sent from, you know, someone's cell phone, you know, forwarding you something, you know, individually from a cell phone, that under the Facebook decision now would no longer appear to be a violation of the TCPA.
Okay, and speaking of TCPA, what does TCPA stand for?
Yes, it is. I know sometimes it's just alphabet soup, isn't it? It's the Telephone Consumer Protection Act.
Okay, and that was our last question.
Yay!
Hey, Deanne, thank you so much for your time and for giving us such great information. I'm sure all of our brokers and agents out there really appreciate all that you've done for us today. I will be sending out the recording of our session this afternoon sometime. And I know, Deanne, you're going to send me those links, so I'll send it all out at one time.
Great.
Other than that, hey, everybody, you have a wonderful weekend, and mahalo to Deanne. Have a wonderful day.
Bye. Take care.
Aloha.